Hello everyone, this is Tom Fox, and I'd like to welcome you to episode number 243 of the FCPA Compliance and Ethics Report. You'll probably notice my new logo I had created for my podcast, where I identify myself as the Compliance Evangelist. So I hope you enjoy the new logo and you continue to enjoy podcasts about all things compliance. The FCPA Compliance and Ethics Podcast is sponsored by Advanced Compliance Solutions. Today I'm going to talk about some of the lessons learned from two recent compliance or FCPA enforcement actions, the Olympus case and Qualcomm. So I will take a look at some of the things that you might utilize in your compliance program going forward based upon these cases. Before I get to that, though, I would like to announce the release of my latest book, Effective Leadership Skills and Compliance, CCO 3.0 and Beyond. It's available on Amazon.com. If you are a chief compliance officer or compliance practitioner, this is the book for you, which will give you help in developing your own skills as a compliance professional. I break it down into communication skills, innovation skills, and influence skills. The book is short and to the point and gives you some solid information both on a tactical and strategic level. Once again, it's available on Amazon.com, and it is Effective Leadership Skills and Compliance, CCO 3.0 and Beyond. Now let's turn to the Olympus FCPA enforcement action. This was a part of a much larger enforcement action where the Olympus Corporation admitted engaging in domestic violations of the anti-kickback statute, the False Claims Act, and a small part around the FCPA. Clearly, the root of the problem for Olympus was it was a culture committed to both bribery and kickbacks, at least as noted by Mike Volkov, and I have to agree with Mike on that point. To add to the ignominy of this case, the Chief Compliance Officer, John Slowick, attempted to stop this behavior and remedy it when he was the Chief Compliance Officer, and for his troubles he was fired. So he reported internally and is terminated for that. Thereafter, he filed a whistleblower and a key TAM case, and according to the Department of Justice press release, he was awarded $51 million for bringing these illegal acts to light. So very significant that the chief compliance officer of a corporation attempted to bring these situations to light and was fired, yet he had a remedy going forward. What this means is that chief compliance officers obviously can be a part of the whistleblower program, and if companies do not take what the compliance officer says seriously, they may take the fine and penalty at the end of the day seriously. The Olympus Corporation was involved in selling endoscopes and related equipment, and it engaged in a bribery scheme to pay kickbacks to doctors and hospitals in the United States, in addition to their FCPA violations in Latin America. What was interesting about this case, because it was in the medical device arena, was the corporate integrity agreement, which is the standard settlement document in lieu of a deferred prosecution agreement that you may be more familiar with in the FCPA context. The corporate integrity agreement stands in the shoes of the FCPA, a DPA, yet it was much more detailed, and some of the things that Olympus was required to do may be cutting edge for FCPA enforcement, but that may portend where FCPA settlement actions are going. Of course, it could be that the Department of Justice didn't trust Olympus, and based upon their prior conduct, that might be certainly a well-justified trust. Nevertheless, the CIA itself had a very detailed compliance program which required the company to have compliance responsibilities at the management and board of director levels, a complete compliance code of conduct, training on specified standards, requirements for consulting agreements, grants, and charitable contributions, a risk assessment and risk mitigation process, and review procedures for testing the compliance program. One of the interesting things was that the company was required to create a compliance committee. The CIA laid out who was to be on this compliance committee, and it consisted of senior executives of relevant departments such as sales, marketing, legal, medical information, regulatory affairs, R&D, audit, finance, manufacturing, and operations. So a pretty broad compliance committee. Even the functional leadership of the compliance committee was specified that it must be the CEO of the company. So clearly a compliance committee is something that you should consider going forward. The CIA required the board of directors to exercise review and oversight of matters related to compliance. This is really one of the few times we've seen the CEO required to do something going forward. The board of directors required to do something. And the CIA laid out specific requirements for the board around its compliance function. Most interestingly, the board was required to adopt a resolution signed by each board member summarizing its review and oversight of the compliance program on a quarterly basis. So clearly the board was directly now in line and has not only their responsibility detailed, but a way for the government to check and see if they have engaged in their obligations going forward. But it went beyond the board level. The senior management was required to certify that each one of their business units was in compliance. A specific certification was listed in the CIA, and it had to be signed and attested to by the relevant business unit head. And if the relevant business unit head could not make the certification, he or she had to explain why they could not do so, and then the steps being taken to remediate the situation. So I'd ask you to consider the power of a similar certification in the FCPA context. This is far beyond the usual employee certification that they have not violated in the FCPA in the past year, which I think has become fairly standard. It proactively requires management to make an assessment of whether the business unit they're running is in compliance with the company's corruption program. And if it's not in compliance, why not, and what the company or that business unit actually is going to do to remediate the situation. In the area of training and education, there were some very detailed instructions which required the company to outline the steps to ensure that employees required compliance training. Within 90 days, high-risk employees had to be trained, and there was a requirement of certification of not only training, but the training protocol as well. Additionally, there was the need for testing to determine whether or not the training had actually been effective. So once again, a few steps past what we typically see in a deferred prosecution agreement. Regarding third parties, the CIA had some interesting insights into the management of the third party. The CIA required the company to prepare annual budgets around consultants, and they had to be identified as to the business justification and reason for using them prior to engaging in due diligence. So the business justification is something that many companies have already implemented and have put into place, but here it actually had to be a part of the budgetary process. And the stated purpose of this review was to determine that there were legitimate and lawful purposes for bringing the consultant into the orbit of the company. So this is something that you may want to consider. This is certainly cutting edge and very much best practices. The next area was charitable donations, and once again there was quite a bit of stringent rigor around this issue. The company had to establish a grants management system, which would be the exclusive mechanism through which employees could request grants or awards be made for medical device or medical services related involvement. It specifically required that sales and marketing have no involvement or influence over this review process. So clearly a segregation of duties here, and much more than a second set of eyes. Really the second set of eyes comes in through the compliance committee, but it's dislinking the business side from charitable donation. In the risk assessment process, the CIA required the company to evaluate and mitigate covered risks. This process required the company to do so on no less than an annual basis, and it required a centrally developed plan to manage these risks. This is a very robust type of risk management process, and I would commend to you to study this CIA, because I really think that this will be the direction the Department of Justice will use going forward in deferred prosecution agreements under the FCPA. The Department of Justice has really evolved in their thinking on risk assessments, not only risk assessments, but the entire compliance structure. And this CIA may give them some ideas about some of the things that you should consider, or that at least they will consider in evaluating your compliance program going forward. You can certainly be sure that the new Compliance Counsel, Wei Chen, has reviewed this, and we'll be looking to see if companies are implementing some of these suggestions. Now let me turn to the Qualcomm case, because Qualcomm was the second of the Princeling cases, which started with the Bank of New York Mellon last summer, where hiring decisions were made in violation of the FCPA. Interestingly, this was a SEC enforcement action, not a Department of Justice criminal enforcement action, so it's a civil enforcement action, and it's for violations of books and records and internal controls provisions. So Qualcomm got into trouble basically for the same reason that the Bank of New York Mellon did, which was that it varied from its own standard hiring protocols to hire the sons and daughters of officials of state-owned enterprises in China. So consider the business justifications for hiring a daughter as set out in the order. We received a request from the general manager of the Chinese company to help find an internship for her daughter within the company. I discussed this with senior management and determined it would be important for us to be given our cooperation with the Chinese company. Qualcomm employees understood that the parents of the daughter being looked at would give Qualcomm a lot of new help in business development, and that this particular person was a strategic partner in China and played an important role in leading other telecom companies or leading Chinese telecom companies to adopting Qualcomm technologies. And Qualcomm employees believed that the internship would be important for the company to cooperate with this particular Chinese state-owned enterprise employee. Additionally, the son of an official was given a $75,000 research grant to help him with study in the U.S., given a Qualcomm internship when he was clearly not qualified, and travel was provided for his parents. And finally, one executive VP provided this Qualcomm intern with a $70,000 loan to buy a home. What was really amazing about the hiring of this son was that after his initial interview, he was rated as a, quote, no hire, end quote. It's because he didn't have the skill set or skill match, but moreover, he didn't even meet the minimum requirements for moving forward with an offer. And then here is really something you rarely see written down by HR. And it quotes directly from the SEC cease and desist order. The Qualcomm team involved in the interview process said, quote, there was an agreement that he would be a drain, not even neutral, on the teams he would join. But he was given a job as a special favor. So when you have a candidate that is so poor that they are given a no hire rating, and then it's noted that they would not only not be a neutral on the team, but be a drain, that clearly tells you that the hiring protocols have not been met. Yet these employees, the son and daughter, were both given jobs. So pretty clear violation of Qualcomm, even though there was no tie to direct bribes being paid. Yet there was one thing that even I found to be a head scratcher in the SEC order. So let me just read this and then I'll discuss it a little bit. Qualcomm offered at least 15 foreign officials lavish hospitality packages worth $95,000 per couple for the 2008 Beijing Olympics. Then in mid to late 2008, a member of Qualcomm's financial department raised FCPA issues related to the Olympics with Qualcomm Counsel. In August 2008, just days before the Olympics began, Qualcomm rescinded the 5 hospitality invitations that had been accepted by Chinese officials, and this was due to Qualcomm's FCPA-related concerns. These disinvited guests were from 3 Chinese state-owned enterprises. So the question is, why was this cited in the SEC cease and desist order? Because it was cited as an example of Qualcomm's failures. The real head-scratching part is this seems to me to be a pretty big success. And yes, perhaps offers were made, and perhaps it's under the offer to bribe prong. Nevertheless, Qualcomm home office, corporate office officials, at least in the finance department, raised the appropriate concerns, and after consultation with legal, these offers were rescinded. So this would seem to me that the detect prong worked, the prevent prong then kicked in and worked, and the remedy worked. So I don't quite understand why this was in the order itself and why the company was even criticized for it. So a bit of a head scratcher there. The Qualcomm case is probably not the last we've seen in hiring. This clearly points to a couple of things, or lessons learned to be learned for the compliance practitioner. First and foremost is that if an employee does not meet your standard hiring protocol, that really should be the end of the discussion. If they do meet the standard hiring protocol and they're a son or daughter, I think you can move forward. But if they don't meet your hiring protocols, they need to be not a part of any positive decisions going forward. The second thing is, as the compliance officer, you need to go talk to HR and you need to make sure that their own protocols are followed. Qualcomm got in trouble for violation of internal controls, and pretty clearly there's a violation of their internal hiring controls. They were overridden because of these business justifications and business unit reasons. So the discussion you need to have with HR is certainly one that's appropriate, and certainly one that these enforcement actions, together with a Bank of New York Mellon, would point towards a much closer rigor between compliance and the HR function going forward. The Qualcomm case also points to the need to identify the son or daughter, or as we learned from Bank of New York Mellon, even the nephew of a state-owned enterprise employee. First of all, if these state-owned enterprise employees suggest or ask that a family member be hired, that's a huge red flag, and that needs to be identified immediately. But if someone comes in through the normal channels, you need to have a way to identify them as falling within the FCPA, so that, if appropriate, additional scrutiny can be provided, basically in terms of whether the parent or aunt or uncle, perhaps a brother or sister, is in the position to award you business based upon your hiring of this individual. So lots to think about from these two enforcement actions. I've written about them extensively. If you'd like any of my written thoughts on this, I hope that you would contact me. Please, you can email me rather at tfox@tfoxlaw.com, and I'm happy to send you some of the lessons that I think are learned from both the Olympus and Qualcomm case. The Olympus case, though, I think is really going to portend where compliance, FCPA compliance, anti-corruption compliance with the UK Bribery Act is going to be going forward. So it's something that I hope you would consider, and I hope you will take these lessons to heart. This is Tom Fox. I'd like to thank you very much for listening to this episode of the FCPA Compliance and Ethics Report. Hello, everyone. This is Tom Fox again, and I have two calls to action for you. The first is I'm developing a list of questions for my next mailbag episode. So if you have a question you'd like explored on this podcast, please email me at tfox@tfoxlaw.com. The second request is that you would go to iTunes and rate this podcast. It would definitely help me get the word out about compliance and my new role as the compliance evangelist. This is Tom Fox. Thank you very much again for listening.